Hello, America. I'm Mark Levin. This is Life, Liberty, and Levin. A great guest, Sidney Powell. How are you, my friend?
Great, thank you. It's an honor to be here.
My honor. Former federal prosecutor. You were, in fact, this is quite remarkable, you worked at the Department of Justice for 10 years. You worked in 3 federal districts under 9 different United States attorneys. It's not that you changed, it's that they change over the course of time when a new administration comes in or what have you. And these U.S. attorneys were appointed by presidents of both parties, right?
Exactly.
And you also have been lead counsel in more than 500 federal appeals, 350 of them as an assistant United States attorney and appellate section chief in the Western and Northern districts of Texas. I just want our audience to know how significant that is, how impressive that is, because there's a lot of brilliant assistant United States attorneys out there. And you were one of them.
Thank you.
And I want to take a very, very close look at Robert Mueller's office. A lot of people focus on Robert Mueller, and they should. But this Svengalian there, my word, is the number 2 guy who Mueller relies on for everything, Andrew Weissmann. So let's focus a little bit on Andrew Weissmann so the American people know who he is and knows who really is the, in many cases, the Wizard of Oz. Tell us about Andrew Weissmann.
Well, I have called Mr. Weissmann the poster boy for prosecutorial misconduct because Mueller had a role in handpicking him for head of the Enron task force and appointing him to that position.
And what was Mueller at the time?
Mueller was in the FBI at the time.
He was the director of the FBI.
Yes.
So he picks Weissmann to handle the Enron case.
Yes. Weissmann was deputy director at the time when they first started under Leslie Caldwell, who was the chief of the Enron task force when it was first created in the collapse of Enron. So they set about and targeted Arthur Andersen to begin with, the venerable accounting firm.
So they're investigating Enron.
Yes.
And they target Arthur Andersen.
Yes.
For what?
For destroying evidence, is what they called it. But they did it by making up a crime, by combining 2 separate statutes to create a crime out of something that wasn't. So they destroyed Arthur Andersen. They knew they were going to destroy the company. Now,
how did they destroy Arthur Andersen?
By indicting it.
They indict Arthur Andersen because they're the financial advisors to Enron.
Exactly. They were the auditors and financial advisors to Enron.
And they manufacture a crime by combining 2 different statutes.
Exactly.
And at that time, how many people worked for Arthur Andersen?
85,000 people worked for Arthur Andersen.
85,000 people. And Weissmann was the lead investigator.
He was the lead prosecutor on that case.
And he reported, in part, he informed the director of the FBI at the time, Mueller.
Yes.
Okay. Well, what did they do?
Well, they knew they were going to destroy the company when they indicted it because Andersen represented 2,500 publicly traded companies. And no auditor who represents publicly traded companies can function as an auditor when they're indicted. So they sealed the indictment for a week while they...
They indict them. Seal the indictment for a week.
Yes.
That's absolute disaster for accountants, auditors, financial advisors.
Yes.
Okay.
And they worked behind the scenes during that week to avoid upheaval in the markets so that when they announce the indictment and unseal it publicly, the markets are not as disruptive as they would have been if they had just indicted them publicly immediately.
What did they indict Arthur Andersen for?
They indicted them under a witness tampering statute. And the way they did it, they essentially took criminal intent out of the process. And in fact, when the Supreme Court later got the case, Justice Rehnquist wrote the decision for the majority, well, for the unanimous Supreme Court, and said it was shocking how little criminal culpability the jury instructions had required, and that Andersen had not committed a crime at the time.
So Andersen gets caught up in this Enron case. Weissmann must know that there wasn't mens rea, or criminal culpability. He indicts the entity, which for a major international corporation is a disaster to begin with, because then you get documents subpoenaed and so forth, and you have to be searching your computers and your records here and all over the world and so forth. So it creates great tumult in a company.
Completely.
And that, in and of itself, depending on the nature of the subpoenas and the indictment and so forth, can freeze a company. And so here's this company, Arthur Andersen, that's in the business of protecting other companies. They're auditors, they're accountants, they're financial advisors. And they're being accused of what? Witness tampering?
Yes, and obstruction of justice under 2 different statutes that combined created this new offense because there wasn't one. Andersen had not been subpoenaed for any documents at the time. Andersen was cleaning up his files and proceeding to get ready for the investigation. So they just made up a new offense by combining the 2 different statutes.
Now, do you recall the name of the federal trial judge that was involved in the case?
Melinda Harmon in Houston.
Melinda Harmon in Houston. And then I assume they appealed it?
Andersen did appeal it.
And what happened on appeal?
The Fifth Circuit affirmed it on appeal.
Affirmed it. Then they appeal it to the United States Supreme Court, which takes the case, which is relatively rare.
Yes.
And the justices look at this. You mentioned Rehnquist, and they say, wait a minute. There's no criminal intent. There's no criminal culpability. This isn't even really a statute. The instructions were faulty. And what did the Supreme Court rule?
They reversed it unanimously.
Unanimously. Every justice said no.
Exactly.
What happened to Mr. Weissman since he led the case?
Oh, absolutely nothing. Mr. Weissman went on to become director of the Enron Task Force. Mm-hmm. In fact, he had already, by the time Andersen was reversed, he had already turned his sights on the Merrill Lynch defendants in what was called the Enron or Nigerian barge case, and indicted 4 Merrill Lynch executives on a multi-count indictment in which they also made up a crime.
I want to get to that in a minute. What happened to Andersen?
Andersen was destroyed the minute it was indicted.
It collapsed.
It collapsed. Not only was it under criminal indictment, so it lost all its clients, but I think 160 civil plaintiffs piled on in multiple lawsuits.
So it was crushed. All those people lost their jobs.
Exactly.
Investors lost all their money.
All the partners lost their money.
They lost everything on a case that was reversed 9-0 by the United States Supreme Court that Mr. Weissman was in charge of.
Yes, and Andersen had been known to be the hallmark, the benchmark for accounting standards. Andersen was the gold standard for accounting, a venerable accounting firm.
Merrill Lynch, you mentioned. Was Weissman involved in that?
Oh, yes.
What happened to Merrill Lynch?
Merrill Lynch was indicted, well, not the company, but I think one of the reasons they indicted Andersen was to send a message to other companies that if they knocked on your door, if the Enron Task Force knocked on your door, you'd better cooperate or you could be destroyed and given the death penalty just like Andersen was.
But even if you don't know anything and you didn't do anything.
Exactly.
That's the power.
That is the power.
That a handful of prosecutors have.
Yes.
And you even see it today with the indictments. When Mueller hands down indictments, it's all one-sided. People need to understand the other side doesn't have any say in it. They haven't had a chance to respond to it. Nothing's happened, but a group of government lawyers have decided to charge somebody or some entity with crimes. That's the beginning of the process. It's not the end of the process, and I want to pursue this with you a little bit more later because the media treat it as, well, that's it. But I want to talk about these executives with Merrill Lynch. What happened to them?
Well, essentially, Merrill Lynch offered them up as sacrificial lambs and entered into a non-prosecution agreement with the government on behalf of Merrill Lynch, the company, that was extremely onerous. In fact, they agreed to have an overseer from the Enron Task Force installed in Merrill Lynch for a period of 18 months to oversee everything, including the bills that the defense lawyers were submitting. They agreed that no Merrill Lynch employee could say anything that contradicted the government's view of the prosecution, which was absolutely astounding and I think illegal. And then the Merrill Lynch executives...
So the government secretes itself within the company it's investigating.
Yes.
To oversee the bills that they're paying their defense accounts.
Yes. And everything else that's going on in the company.
Sounds thoroughly unconstitutional. These 4 executives, they're indicted. What happens to them?
Their lives are destroyed. They went through a 10-year period of unmitigated hell. There was the investigation, and then they're indicted, and then they face trial. The trial was a circus. I detail it at length in my book.
This book?
Yes.
License to Lie.
Yes. They were tried in Houston in the wake of the
Enron.
In the wake of the Enron collapse.
So people were angry.
People were furious. Anderson had just been convicted, so there was all the uproar about that. All of Houston was in turmoil because of the collapse.
So what
of Enron.
happened to these four?
They were all convicted. The lawyers for the defense were like deer in headlights most of the time. They were blindsided at every turn.
By the government.
By the government. They had made repeated requests for what's called Brady material. Because the government holds all the cards in a criminal prosecution, the government is legally, constitutionally, and ethically required to produce any evidence that is favorable to the defense, that is within the government's possession or within its reach. Oh no, they steadfastly denied that there was any such Brady material. When the defense kept making demand after demand after demand, the judge at the time, Judge Ewing Werlein, who was assigned the Merrill Lynch case, finally made the government produce a list of people that they had admitted might have some Brady material. And then upon further demand, he finally ordered the government to produce summaries of that material.
When we come back, I want to know ultimately what happened to these four executives. Then I want to continue to examine Mr. Weissman, because it's very, very crucial, and beyond that, how this special counsel's office is operating. Ladies and gentlemen, don't forget, most weeknights you can watch me on Levin TV, Levin TV. Go to blazetv.com/Mark. I hope you'll sign up there, blazetv.com/Mark, or give us a call at 844-LEVIN-TV, 844-LEVIN-TV. We would love to have you at our conservative town hall over there.